staff indicated that. You can argue with me all you want, Ms. Toe. What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading, you signed it. Your former client had no knowledge of it.
That is not,
was delayed.
Not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond. The amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to and the delay that you caused. It was set in that amount. What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14th, 2026, 9 a.m. Thank you. Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Yes.
Good.
State your name.
Donna Tope. I'm hearing on behalf of myself.
Ms. Tope, I had issued a bench warrant for your arrest. Failure you to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt, and the warrant for your arrest. That is your motion before the court today.
Yes.
Go ahead.
So I would like to put this on the record for my own purposes and also for YouTube. The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and for other cases. And therefore, I would like to have this on the record.
Have what on the record?
What I'm going to tell you now in my defense.
Go ahead.
Okay. It's my motion. The following enumerated facts support my motion to remove and expunge from every record, including the YouTube video, A, your order for contempt, your warrant issued for my arrest, and your order to hold me under arrest on $10,000 cash bail. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Weedling. I opened the email the morning of Tuesday, February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney. Not having had any notice of appearance for this hearing, I was not able to get to the court in time, so I sent Ms. Weedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I receive all of my business mail at Post Office Box 1283 in Ann Arbor, Michigan 48106. I check my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Weedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box, 2 days after the hearing was held. The photos included with my email to the court are of a motion affidavit in order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. The motion at number 2, page 1, states, I am being held by the judge in contempt for filing a pleading without my client's knowledge, nor being the attorney of record. At number 3 on page 1, Judge Simpson requests an order to show cause why I should not be found in civil contempt of court. Can you attach it for me? Thank you. At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2 of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th. The date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the quote, service by mail within 14 days required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, and only 8 days after it was mailed, which is 6 days shy of the required 14-day notice by mail. The facts are that I was not properly served nor properly noticed of the hearing at which Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. Based on what I have provided, the judge's motion and order and the mailing envelope, I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge, so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts, and reissue with proper notice to me the show cause hearing the judge wishes to impose upon me. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice. I will stand on the record that Brandon Davis, no response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Court calls case of People versus Theodore Edwards.
David I. Goldstein. Theodore Edwards. We have a plea worked out in this matter, Your Honor. Mr. Cook is going to add a count of
Do I have
the advice of rights.
I have the advice of rights? Do I have a plea form?
Oh, no, sorry.
I'll pass it. Yeah, please. Court calls case of the People versus Micah Elkins.
People. For the judge. Court shall feature assistant public defender on behalf of Mr. Elkins, who I hope is present.
Yes, Your Honor.
State your name.
Michael Elkins.
Thank you. All right, what are we doing?
Thank you, Judge. Looks like Mr. Elkins' license was still suspended last week, and he's still trying to get that resolved. To adjourn it or set it for final settlement conference, whichever the court's pleasure is, Your Honor.
April 15th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case People versus Sincere Godwin.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Godwin.
Sincere Godwin. Yeah. Bench warrant will issue for defendant's failure to appear. Bond is setting amount of $7,500. Give a 10% privilege. That warrant will issue immediately. Court calls the case of the People versus Tony Gomez.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Tony Gomez.
Tony Gomez.
Your Honor,
Yes.
we're in the process of having him evaluated for the Veterans Court in Dearborn. I've been in contact with him as of yesterday. I'm requesting an adjournment so that we can complete the process. My colleague did submit, I believe, a MOU in November. Ms. Perini.
I don't know, but we don't know where he is.
Your Honor, he is not in custody, but I've spoken to him all Friday, Monday, Tuesday.
Well, I'm going to issue a bench warrant. Bond $7,500, 10%. That warrant will issue the 20th. Okay. So calls case of People versus Joseph Hamby.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Hamby, Your Honor.
State your name, sir.
Joseph Hamby.
What are we doing?
I'm requesting an adjournment, Your Honor. April 15th.
Why?
My information is the vehicle in question is not drivable. I'm trying to obtain verification of either transfer of title or scrap title so that there's no vehicle, proof we have no vehicle in the household.
April 15th, 9 a.m. Fine, continue. Court does call the case People versus Wilmer Hudson.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf. State your name, sir.
Homer Hudson.
I have a plea form indicating that he's going to plead to attempted resisting and obstructing the 1-year offense upon a successful plea to, well, this form isn't filled out correct. Well, is this charged as an attempt?
Yes, it is. Yes, it is.
So he's pleading as charged to attempted resisting and obstructing. And then there's a prosecutor who will recommend no upfront jail. That's the court's full understanding.
That is correct, Your Honor.
Yes, sure.
That will flow.
Raise your right hand. Do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth? So help you God. State your name, please.
Homer Hudson.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yeah.
Still wish to plead guilty?
Yeah.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You've signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
May 5th, 2025, at the location of Ellsworth at Stone School Road, Pittsfield Township, Washington County, State of Michigan. Did you come into contact with officers from Pittsfield Department of Public Safety?
Yes.
What happened?
Well,
Did they order you to pull over and exit your vehicle?
yes.
And did you refuse their lawful commands to pull over and exit your vehicle?
Yes.
All right.
And they were in uniform and you knew they were Pittsfield police officers?
Yes.
All right. Sir, I do have to advise you if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
9th at 12 noon.
April 29th, 2026, 12 noon.
I'd ask bond continue.
Continued. Court calls the case People versus Austin Ingram.
Your Honor, read for the people.
Marshall Feaster, Assistant Public Defender, on behalf of Mr. Austin Ingram.
During the name, please.
Austin,
Hi.
state your name. Say your name, please.
Austin Ingram.
Thank you, Judge. I did speak to Mr. Ingram and father yesterday. I believe they're requesting this matter be set for final settlement conference and jury trial, Your Honor.
Jury final settlement conference in this matter, April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Judge.
Bond with its conditions will continue. Thank you.
Thank you, Judge.
Court does call the case People versus Devon Foster.
Raymond Cook for the people.
Yeah.
Judge Torshell Feaster, Assistant Public Defender, appearing on behalf of Mr. Javon Foster. Please state your name for the record.
Devon Foster.
Thank you, Judge. It looks like he was recently arraigned. I believe we'll be asking for an adjournment to speak to Mr. Foster and see what possible resolutions there are.
During the matter, April 1st, 2026, 9 a.m. Bond continues.
Thank you, Judge. You got a comment?
Good. Court recalls the case of the People versus Theodore Edwards.
One, Your Honor, Raymond Cook for the people.
I Goldstein is bringing on behalf of the defendant. Theodore Edwards.
Now, Your Honor, we have reached a plea agreement. He's going to plead guilty to an added count of retail fraud third and make restitution. Exchange the people are dismissing the original charge.
So, he's agreeing, the defendant's agreeing that he'll pay restitution.
Yes, Your Honor.
Your Honor, for what it's worth, I don't believe there will be any restitution owed on this case. My understanding is
Okay, yeah, but if there is any, obviously the agreement is he will pay.
Okay. And I just added that to the form. That he agrees to pay restitution if any. And that's the court's full understanding of the agreement. Is that correct?
Correct, Your Honor.
Haven't sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. State your name, please.
Theodore Edwards. Sir, it is this court's understanding that you are going to be pleading guilty to the charge retail fraud third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
They wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yep.
You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes,
You understand you're giving up your right to appeal of right.
correct.
Are you on probation or parole?
Misdemeanor.
He wasn't at the time of this offense, Your Honor. He is now.
Has anybody promised you anything other than what's
No,
stated here today on the record to get you to plead? Anybody threaten you or coerce you?
no, Your Honor.
You're doing this voluntarily
Absolutely.
of your own free will
Yes, sir.
and because you believe that you're indeed guilty of this offense?
Correct.
On the date of July 21st, 2025, at the location of 3749 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Target store that makes you guilty?
I had some items that wasn't purchased.
Okay, so you went into the store,
Yes.
picked up some items and tried to walk out without paying for them?
Yes, sir.
All right. And the store was open to the public at the time?
Excuse me?
The store was open to the public at
Correct.
You didn't have anybody's permission to take that property, did you?
No, sir.
And the property that you took was property that Target had offered for sale?
Absolutely.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court has to advise you that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Correct.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant's referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2006.
29th, Your Honor, that's fine.
Yes, 12 noon.
9, I'm sorry,
Bond will continue.
9 o'clock,
Noon.
noon.
All right, sir, make sure to stop down at my probation department about halfway down the hallway.
Okay.
All right, on the left-hand side.
All right.
May I approach for a moment, Your Honor?
Ma'am. Well, that was fun. Court does call the case of the people versus Albert Wilson.
And your agreement close to the people.
Your order on behalf of the defendant, John. Appreciate the brief adjournment, court permitted to discuss this. With Wilson, he has read the advice form that was tendered to him. He's re-signed it. It's put your ears up. Yeah. Okay, good.
You hear me?
Yes.
All right.
And he has signed it, so I'm sure that he's familiar with it, Your Honor.
All right.
We've also
Are you
signed.
signed and gone through that advice of rights form, sir?
Yes, I did.
Any questions regarding any of those rights?
No.
All right, look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, he said that.
All right. You understand that you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, he signed it.
Has anybody promised you anything other than what's been stated here today,
File.
which is nothing? Get you to plead to this case.
No.
Anybody threatened you or coerced?
No.
You're doing this voluntarily and of your own free will?
Yes, I am. Your Honor, I might amend that if I might. We have an agreement with the prosecutor that the prosecutor is going to recommend community service. And if the court doesn't give him community service at the time, then he has the right to withdraw. That's the only,
I am not, you guys can agree to, I am not agreeing to.
I understand that, Your Honor.
And to make it clear, the plea form that I believe was handed over says that the people are recommending the community service instead of jail. I understand that the court is not bound by that, but that's what the people will be recommending.
Yes, Your Honor. The other thing we would request is in discussions with the prosecutor, Mr. Wilson has had, as I think the court is aware, has had some difficulty justifiably or not, with the testing of required by the court. And the prosecution suggested that he wear a scram, and Mr. Wilson is okay with that. If the court
I don't know
will accept that.
with that now. I'm in the middle of a plea. I don't even have a plea.
I just wanted to make that clear to you, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today, which is really, as I said, nothing to get you to plead?
No,
Has anybody threatened you or coerced you in any way?
no.
Doing this voluntarily and of your own free will?
Right.
And also because you believe that you're guilty of this offense?
Yes.
September 7th, 2024, at the location of 5915 West Michigan Avenue, Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What did you have and how much?
Well, it's vodka, but I don't exactly know.
All right, but you were drinking vodka before you drove?
Yes.
All right. Were you stopped by the police or was there an accident?
Well, I wasn't neither, actually. I was stopped in a parking lot when I walked out of a building.
Okay, so you drove, you would admit that you drove into a parking lot?
No, I didn't go into a parking lot. I parked on the side of the road. The Michigan Avenue was torn up at the time, and they were laying down asphalt. And to get into the liquor store,
Pardon?
get into the liquor store, I would have had to drive over a big bump. Like the asphalt, but it was maybe a foot, and I thought it might hurt my car. So I parked on the side of the road.
Okay, so you drove to the side of the road, you parked on the side of the road,
Yeah.
went to the store,
Yes.
you came back out.
Yes.
Okay, but you admit that where your vehicle was parked, you drove it to that location.
Yes.
All right. Did the police arrive? Or they were out there when you came out?
An officer walked up to me when I came out of the building.
When you came out of the store?
And he put handcuffs on me. So on.
Okay, he didn't put handcuffs on you right away.
He did.
Did he say why he was doing that?
No, he didn't arrest me.
What?
Well, as far as verbally, no, he didn't arrest me. I don't recall that at all. He took the package I had in my hand first, and he put handcuffs on me. And a little later, he asked if I take a breathalyzer, and I said no. And yeah, that's what happened.
Okay. Are you challenging the right of the police to stop you and arrest you in this instance?
Well,
No,
no,
thank you.
Well, what?
You're not challenged.
I do not challenge.
Okay. And so you were ultimately arrested.
Yeah. Yes, Your Honor. Phew.
Were you taken to the hospital for a blood draw?
Yes.
What were the results of that blood draw?
I don't know. Supposed to have the record.
Would it be 0.124?
I don't know.
Okay, if I told you it was 0.124, would you have any reason to dispute that?
No.
All right. Sir, were you previously convicted on or about February 15th, 2022 in the 14A4 District Court, that being Saline, on the charge of operating while intoxicated?
Yes.
All right. And sir, I just so that our record is clear, when you parked that vehicle on the side of Michigan Avenue,
Yes.
correct?
Yes.
You had drank vodka prior to arriving at the place where you parked that vehicle.
Yes.
All right. Sir, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I understand, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon. As to bond in this case, he wishes to be switched to, he's currently on a sober link, right?
Yes, Your Honor.
And he wishes to be switched to a scram?
Yes, please.
I will switch the defendant. We'll prepare an order switching him to a scram. Do you have the sober link with you?
Yes.
All right, you can go over there. We'll send the order over and do that. Anything else on this?
No, thank you, Your Honor.
Oh, pardon?
That's it for 9 a.m.
That's it for 9 a.m. All right, then I'm gonna take a break. My first one. Court does the case of People versus Jason Smith.
Brett Silver on behalf of Pittsfield Township.
Court shall feature Assistant Public Defender on behalf of Mr. Smith. Mr. Smith, please state your name for the record.
Jason Smith, good morning, Your Honor.
Good morning, sir.
Thank you, Judge. I did meet with Mr. Smith. He does have some other cases at circuit court pending. If we can adjourn this matter to the end of April or early May. We think we can get everything resolved.
What's my last date in April? What's my first date in May?
Basic.
Turn the matter to May 6th, 2026, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Aisha Anderson.
Morning, Your Honor. Raymond Cook for the people.
They should be coming.
Oh. Well, let me do this. Court does call the case. I don't want to take it. They coming. Grace Anderson, that's you, man?
Yes, yes.
All right. Ms. Rushing? Okay. Miss Rush. Oh, she.
Sorry, Judge. I was on the record in the court. Good morning, Your Honor. Sydney Rushing, appearing on Ms. Anderson. I am saying in for her attorney, Mr. Brandon. Ms. Anderson, is that correct? And with your permission?
Yes, yes.
All right. Very good. All right. What are we?
Your Honor, in this matter, all of Ms. Anderson's matters have been submitted to the mental health court for consideration. We're asking for this case to tag along with those matters. So we're just asking for adjournment. I believe that you set next PCC date out to, I believe, the beginning of April.
All right. So I'll adjourn this. I have April 1st.
Yes.
I'll adjourn this matter to April 1st, 2026, 9 a.m.
Thank you so much, Your Honor.
Thank you.
See you tomorrow. Have a great day.
Two. Court calls the case of People versus Penny Muldoon.
Your Honor. Raymond.
Good morning, Your Honor. Edward Lucas,
Half of Muldoon Coaching.
Hello, what's your name?
Penny Muldoon.
I have a form indicating that she's going to plead to an added count two of operating while impaired 93-day offense on us. That charge. One is the court's full understanding of.
That's correct, Your Honor.
Yes, Your Honor.
May I have her sworn?
Raise your right hand. You tell them the testimony about to be the truth, the whole truth, and nothing but the truth, so be God.
Yes.
State your name, please.
Penny Lynn.
Ma'am, it is this court understanding that you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days of jail, up to $300 plus court costs. The court could order community service and rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of prosecution as well as cost of emergency governmental services. You understand that?
Yes, sir.
And understanding that, you still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Guilty.
That you understand by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed it by the advice form, is that correct?
Correct.
Any questions regarding those rights?
No.
Please look at paragraph 5, you say copy on the podium, those are your rights to trial. You said by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir. I understand.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record? Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
On the date of September 29, 2025, at location 400 South State Street, Pittsfield Township, Washington State, Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, you ingested a controlled substance.
Yes, sir.
And that was cocaine?
Someone gave me a and I knew it was from the streets. A Percocet. So I didn't really know what was in it.
Okay. When you say somebody gave you something, you don't know what you took.
I believe it to be a Percocet, but I knew it wasn't.
Okay.
It was not prescribed to me.
It was not prescribed.
Correct.
Okay. Were you stopped by the police or?
I was driving someone to work in the morning. I remember pulling away, not feeling very well, pulling off to the lawn, and that's the last thing I remember. I fell asleep.
So you were on South State, and at some point you drove off the road.
I was in a parking lot of a factory.
And at some point, operating vehicle, you drove off the asphalt onto grass.
Yes, sir.
To a grassy area.
Yes, sir.
All right. Did the police arrive?
Yes, sir.
Were you ultimately arrested?
They sent me to be tested.
Okay.
They drove me to the hospital to be tested.
Cuffs?
Yes.
During cuffs?
Yes, sir.
You were probably arrested.
Yes.
Okay. So they took you to the hospital. Right.
Mm-hmm.
And then there was a blood test.
Mm-hmm.
Yes,
sir.
All right. And did the results of that blood test indicate the presence of cocaine?
Yes, sir.
All right. Do you have any reason to disclose blood test results?
No, sir.
All right. Taking everything into consideration on that date and at that time, you believe that your ability to operate that motor vehicle was impaired during your ingestion of a controlled substance?
Yes, sir.
Ma'am, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises or other impeachments that led to this?
None from people.
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant count two. Count one is dismissed. Defendant's referred to for alcohol screening, assessment, victims, impact panel, sentencing matter will be April 29, 2026, 12 noon. Bond will continue.
Thank you.
And stop down at my probation department left on the way out.
All right.
Thank you. Court does call the case of People versus Thomas Kumaska.
Conrad Silva on behalf of
Kumasaka.
Good morning, Your Honor.
Your name, sir?
Thomas Kumasaka.
Your Honor, I'm asking for an adjournment in this case. He has a next Thursday, and my understanding there's going to be a resolution on that day, and it's going to resolve our case. So if we could adjourn it till after first. Thank you.
2029 AM bond continue. Thank you. Court calls the case People versus Austin North.
Conrad Silva on behalf of
There's no rain on this. Good morning, Your Honor. Robert Ellman on behalf of Norton. In terms of the arraignment, we would stand mute and wait for reading. Mr. Norton, can you please state your name for the record?
Austin Norton.
If we wait for reading, standing mute, or not guilty, please. What are we doing? Your Honor, Mr. Soler and I are working on a resolution of this case. We need a little more time to get some of that paperwork done. I'd be asking for a little bit longer of an adjournment if you would to April 15th. Yes, sir. During the matter to April 15th, 2026, 9 a.m. That's the defendant's bond will be set at $5,000 over bond. All standard conditions, including no assault behavior, or possession of any weapons or ammunition, you understand?
Yes, sir.
And I'm also gonna order this time no possession of any alcohol, recreational marijuana, or illegal. Do you understand that? Okay. Thank you. Court calls case People versus Christian Bird.
Conrad Silva on behalf of Township.
Very good. For sure, sister, on behalf of Christian Bird, from the podium. When you arise, please state your name for the record.
Christian Bird.
Thank you.
Thank you, Judge. I did meet with Ms. Bird yesterday, and I did speak to Mr. Chabalowski, who has her case up for tomorrow in front of UCC. We're working on a golden resolution. Brief resolution, please, Judge. Brief adjournment.
During the matter, April 1st, 2026, 9 a.m. bond continue. Thank you.
Thank you.
Court calls case the People versus Joshua.
Your Honor, the people.
Good morning, Judge. Larry Margolis with not but on behalf of Mr. Wara. Let me give you an update, Judge. What went down since you modified the bond. Josh was released into the custody of U of M ER. He is now presently at Havenwick Hospital. I've been advised that his stay is 7 to 14 days, but I'm working on obtaining the admittance discharge paperwork from U of M, and I will provide it to your court staff. I'm asking for 2 to 3 weeks adjournment.
That objection, April 1st, 2026, 9 a.m.
Thank you, Judge.
Thank you.
Bye.
Court calls case People versus Norman John. Norman Johnson.
Sherilyn Tucker on behalf of Norman Johnson.
Norman Johnson. Thank you.
Your Honor, we're requesting an adjournment. He has a case up at court, and we're working on a global resolution.
Sad.
I think his next pretrial is Monday.
Monday.
2020. Yeah.
April 1st, 2026, 9 a.m. Bond continue.
Thank you.
Court calls the cases of the People versus Ryan Brown.
Your Honor, the people filing.
Ron Brown on behalf of Ryan Brown.
Yes.
Which one?
610.
Here. Ryan Brown. No response. Bench warrants will issue for the failure to appear in each of these matters. Bond will be set in the amount. $5,000 detention on each case, those warrants will meet. Court calls the case.
Yeah. Great.
And contact Paul, make sure he's gone. Court calls the case, people versus Justin Randolph.
Township.
For the judge, first defender on behalf of Justin Randolph, who I do not believe is present, Your Honor. There was a progress report that was sent to our office that indicated that Mr. Randolph County Jail via violent.
What?
They believe that he was in Livingston County Jail. It's on a violent search.
Okay, they made there.
Yes.
Okay.
Requesting
Want me to do it tomorrow?
Yes, please.
We try to do that. I'll do these matters April 1st. 2026, 9 a.m.
Thank you.
Bond will continue these matters. Court does call the case, people versus Palmer.
You want to ring the coach?
Done. Your name, sir?
My name is Paul, sir.
The PD.
The public defender case. Well, they don't have all listed. Fine.
Ready, Judge. First defender on behalf of Mr. Palmer. Nice to meet you, sir. Please state your name for the record.
Reese Paul.
He is not.
Equal.
All right.
On to do.
All right. What are you gonna do today?
When I adjourn your courts and arrange you. He's looking at you. We're ready, Judge. Did you say you had to arrange?
No, he's been arraigned.
Okay. Thank you, Judge.
Yes, sir. This is what I'm trying to do. I got stage 4 cancer, sir.
Pardon?
I got stage 4 cancer. When I caught this case, sir, when I got this case a year and a half, almost 2 years ago, whatever it was, I was homeless. Now I'm not homeless. I'm on disability. And I can't take chemo while I'm in the county jail. So please, I'm trying to get a personal bond so I can get out and take my stage 4 chemo. This the last chance I got. If this don't work, then definitely I got to go see God.
All right.
I guess that's bond request, Your Honor. He's requesting.
Well, if I can get information, I'm not going to have a problem release.
Okay. He needs some proof.
Does he have other cases pending?
Your Honor, he has another case that he sees tomorrow, $1,000 trying to chill right now, sending out counsel. I would looking in our system, I do see new cases with dates of February 21st and March 10th. I've not looked at those, but those like they requested charges.
What I'll do is adjourn this matter to April 1st, 2006, 9 a.m. And if I can get medical, then we can try to figure out what terms we
reach out.
What makes this moment so powerful isn't just the judge's tone. It's the reminder that courtroom procedure is not optional. Filing documents without authority, missing deadlines, and interrupting the court can quickly escalate into serious consequences like contempt charges and even arrest warrants. But at the same time, the court showed something important here: discretion. Even after the mistakes, another opportunity was given to correct the situation properly. And that raises a bigger question. When does the court draw the line between second chances and accountability? Let me know what you think. Was the judge too lenient or exactly right?